Welcome. My name is Ian De Witt, and in these two short 5-minute videos I'm going to have a very brief look at some history relating to third-party litigation funding and the principles that have inhibited its development. The principles I refer to are commonly known as champerty and maintenance, but actually there are three restrictions. The first of those is barratry, which is derived from a case of the same name that was decided in 1587. Now, that's the same year that things didn't go exactly according to plan for the Spanish Armada, and the year that Queen Elizabeth I signed the death warrant of her cousin, Mary, Queen of Scots. So you thought you had family issues. It's defined as persistently stirring up quarrels in the courts. Second is maintenance, which is the procurement by direct or indirect means of another person to institute or carry on civil proceedings without lawful justification. And finally, there's champerty, which is an aggravated form of maintenance where the maintainer receives a share of the proceeds of the action. Originally it was in return for a share of land. In fact, the word comes from the expression division of field, or in Latin, campi partitio. Now, most have heard of champerty and maintenance, less so barratry, but it is still around. A look into recent US press finds this. A Texas attorney was accused of paying an employee to illegally solicit personal injury clients. He then fired her for not complying, and after she became a key witness in the state's case against him, he attempted to hire someone else to murder the woman. Only in America. So, how did we get these champerty and maintenance prohibitions into our legal system? Well, this is Adam Smith, a pioneer of political economy, the founder of free market economics, who wrote his Wealth of Nations as the American Revolution was starting. Genius though he was absent-minded. He used to talk to himself. As a child, apparently, he was kidnapped by gypsies. Lady Thatcher is said to have always carried a copy of his book in her handbag. He pointed out that economic activity, productivity, and innovation will only thrive in an environment where there are secure property rights, freedom to trade, and effective mechanisms to enforce contracts. People have to be able to trust that contracts mean what they say, and therefore the state has to provide fair and clear laws applicable to all and a legal system and cost structure accessible to all. In other words, the rule of law. And barratry, maintenance and champerty all helped to ensure the rule of law. How and why? Well, to answer that, we need to go back a little further in time. Champerty goes back to classical Athens. As there was no police force, that wouldn't be invented for a long time, and only a limited number of public prosecutors. Most legal cases were brought by private litigants. But by the 5th century BC, this practice had given rise to abuse by litigants who brought unjustified prosecutions. And the people who did this were called, interestingly enough, sycophants. So the Athenians made efforts to discourage or suppress these sycophants. Now, this may look like a director's meeting, but this is in fact a court scene of old Rome where the sycophants are being forcibly ejected. Of course, in modern English, the meaning of the word has shifted, but in any event, somehow, through the mists of time, this concept found its way into English law. It probably developed in England as a result of the medieval feudal system, where the various barons and nobles ruled their small kingdoms. When they came into conflict with each other, especially in respect of land disputes, they would resort to trial by battle or combat, known as the judicial duel. Now, these noblemen also had their own private armies, so they could take the law into their own hands and wage private wars against each other. But this proved costly, and slowly the concept of judge and jury started to take root. First, trial by ordeal was replaced with trial by jury. And with the emergence of the legal profession in the 13th century, lawyers steered people away from the wager of battle. It's easy to get your bills paid that way. And the barons eventually had little choice but to use the courts. But old habits die hard, and attempts were made by the barons to bribe or intimidate judges and juries, and generally cause trouble. The burgeoning legal system needed protecting. Sir William Holdsworth, the legal historian who really can carry off a moustache, described it thus: when those who are wronged are compelled to have recourse into the law, much of the unscrupulousness and trickery which accompany the waging of a war are transferred to the conduct of litigation. The courts are besieged with angry litigants who fight their lawsuits in the same spirit as they would have fought their private or family feuds. This was especially apparent in medieval England. Contemporaneously with the growth of the power of the royal courts, we get the growth of the various attempts to pervert their machinery. So the development of the prohibition on maintenance was the means by which attempts to abuse the litigation process were combated, to stop the law itself becoming an instrument of repression. And this was all happening at a very, very interesting time in world history. Now here we have King John, not everyone's favourite king, the baddie in all those Robin Hood films, the one that the evil sheriff of Nottingham worked for. Anyway, he had a bit of a falling out with the barons, who were fed up with him losing wars, putting up taxes to pay for them, losing possessions in France. Peace was eventually made when the king and the feudal barons signed Magna Carta in 1215, which guaranteed that no freeman is to be taken or imprisoned or disseized of his free tenement, or of his liberties or free customs, or outlawed or exiled, or in any way ruined. Nor will we go against such a man, or send against him, save by lawful judgment of his peers, or by the laws of the land. To no one will we sell, or deny, or delay right or justice. So what happened next? Well, you'll have to watch part 2. Thank you for listening.